Thank you, Sabina. Let me start off by saying no, I'm not a lawyer and I'm not a paralegal. I've just been interested in this stuff for as long as I can remember. I'm going to start this off with the state's objection to the defense's motion to suppress that was filed April 26, 2024. The state says that on October 26, 2022, Richard Allen and his wife came freely and voluntarily to the Indiana State Police Post in Lafayette under his own volition to talk about the return of his vehicle after it was searched. When he got there to speak about getting his vehicle back, he was asked to talk to Lieutenant Jerry Holman. Richard Allen was then taken to an interview room, and Holman came in and asked him if he wanted to talk about the search of his home. And according to Holman, he told Allen that he was free to leave at any time. Anytime a cop tells you that, leave. Just walk away from there and to a lawyer's office for advice. At the least, law enforcement doesn't have to offer you a lawyer until they place you in custody. But you also don't have to give them a statement or answer any questions about the incident, so don't. They're your rights, don't give them away. In custody means more than being under arrest. And some examples of when courts have found that a person was in custody have been having multiple cops surround you or your car and displaying weapons, having a cop take your keys or phone or other actions that made you feel like you couldn't leave, officers using a coercive tone, and trying to conduct lengthy questioning. Also, you shouldn't make voluntary or spontaneous statements. State also says that there was 3 chairs and a desk, with Holman being the only law enforcement in the room. The door wasn't locked, and they say all Richard had to do is get up and go past Holman, open the door that Holman would have been sitting in front of. They always position themselves between the door and the interviewee. Walk down a hallway and exit through a set of doors, and hopefully you know which set, because I'm sure there's more than one set. He then would have been in the lobby. Now, unfortunately, sometimes the way many are raised is to respect all law enforcement and go to them when you need help. We're not taught to get up and just leave, walk away. That would be rude, plus make the interviewee look more guilty, we think. Let your lawyer deal with that. Just walk away, just leave. The room is set up very sparse and rather hard or unfriendly looking to make you feel uncomfortable and powerless when they're being so nice and polite to you. Do you want something to drink or something to eat? Is there anything else I can do for you? And they tell you, we only want to clear a few things up. All this is nothing more than tactics to show that all your needs are being met, because you better believe that you're being videoed. They're not there to befriend you or to just talk to you. If they bring you into an interrogation room, the chances are very good that after they finally finish with you, probably in some hours, you're not walking back out of that room without cuffs on. So when you have the chance, just leave and go to a lawyer. Most will give you a free consult, and then you'll at least know what to do in the immediate situation. Then, if you're arrested, don't let them smooze you. Don't talk beyond your name, address, phone, etc. until they provide you with a lawyer. They haven't brought you there to clear the air or make sure the information they have is correct. They're there to get evidence against you and to clear a crime off their books. Look up the way Ruby Franke acted when she was placed under arrest. She was a monster, and that was proven. But the way she acted when arrested is exactly how you should act. Then they asked Richard, according to them, if he remembered his rights from October 13th, the last time he spoke with police, and if he understood them. And Richard affirmed that he did. What kind of mess is that? What are the chances that you'll remember every word of a conversation you had 13 days before? Even if you remember the gist of the conversation, you could forget an important aspect of it. But it is allowed for up to 14 days, and there's some muddy waters in there because it says the rights need to be invoked again, not necessarily read again. It seems there is no rule about it that I could find, but there certainly should be. They should have to be read every time they question you. Those rights are too important for you to say, well, you remember them and understand them, right? So they say that during the approximate 1 hour interrogation, Richard was given multiple breaks, with one given for him to go to the bathroom and outside to smoke. Again, when it's an option to leave, leave. Cops are allowed to, and they do, lie to you about evidence, other confessions that people have made, stuff like that. Again, leave if able, and if you're not able to leave, then tell them you want a lawyer, and say only that. And once again, I'm not a lawyer, so always consult with a lawyer, so you'll know what to do in such situations. Then we have the motion in limina. Old Slicky Nicky is asking that the courts rule that the defense not be allowed to, in the presence of anyone connected to the trial before, during, and after trial, to make any references, directly or indirectly, to make any comments about the prosecution that constitutes a personal attack. So they don't want the defense to say anything bad about the prosecution. Any comment which constitutes the personal opinion of the defense about any witness, evidence, outcome, penalty, including law enforcement. Not to make any innuendo or inference that isn't supported by the admissible evidence, and not make any attempt to suggest at any time before, during, and after trial to the jury any substantial issue in this case. Prosecution wants them to not be able to ask any hypothetical questions that don't include facts that aren't in evidence, or questions not considered to be helpful. I don't know who's doing all this consideration and the criteria for helpful. Maybe the judge, I guess. That's fair. Prosecution wants the defense to not be able to introduce any third-party evidence of motive not considered relevant or has probative value until the defense shows some connection between the crime scene and the third party, which would be very difficult to do since the defense can't make any hypothetical questions or suggestions or comments that may suggest at the personal opinion of the defense. And to order that defense is not allowed to mention Odinism, cult, or ritualistic killing, Brad Holder, Patrick Westphal, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Kline, Jerry Klein, or Ron Logan. Prosecution also wants an order that the defense can't make any reference to Todd Klick's investigation, including any of his reports or investigative material not considered relevant or that could be considered misleading. So I guess them getting to the truth would be considered misleading. He doesn't want them to be able to make any reference to geofencing and our testimony from Kevin Horan about geofencing or the findings from any geofence search that isn't considered relevant, And again, of course, they must show why it's relevant without mentioning anything about anything, like asking hypothetical questions or suggestions or making comments that may suggest the personal opinion of the defense. None of that, but prove it. Prosecution, not surprising at this point, I guess, doesn't want defense to be able to make any reference to any bad acts or acts of any witnesses that plan to testify at the trial that is not considered relevant to what Richard is on trial for, or that tends to negate the guilt of the defendant. Really? Oh my goodness. And prosecution also wants no reference to how the files were labeled that were handed over to the defense as a part of discovery that aren't, relevant. Prosecution wants no reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation into the murder of Abigail Williams and Liberty German. That aren't, and I'm beginning to hate the word relevant. Plus, they don't want the defense to make any reference to the fact that this motion has been filed and granted. He sounds kind of sure of himself there, that it's going to be granted, but I guess at this point, he's got the right to be confident that it will be granted. They don't want the jury exposed to any substantive issue in this case. Of course they don't. They really filed a motion for the judge to tell the defense to defend their client without using any evidence that defends their client, who is Richard Allen. So I guess the defense is just supposed to say Richard Allen is innocent. Or would that be considered facts not in evidence? This is just absolutely ridiculous. And what's more ridiculous is she probably will order it. So what all this says to me is that they know Richard Allen is innocent and don't care. That they know they're using him for a scapegoat and they don't care. That they know guilty people are still out there and they don't care. But there are people who care about our justice system, about our rights, and about the murder of 2 little girls. Thank you all for coming by.